Thank you, Naomi, for warming things up, and thanks to the Federalist Society and the Foundation for Defense of Democracy for bringing us together. State the obvious at the outset, why we're talking about law instead of talking about war. Well, law matters a great deal in any war, and particularly in this war. I'm just going to very briefly run through what I see, however. While law does matter in war, judges seldom matter. That's not the case now, and I don't think it's a good thing. Then, a little less than 2 years ago, a federal district court judge ordered the release of 17 so-called Uyghurs into the United States. He took to perhaps its logical conclusion, judiciary's increasingly bold attempts to determine matters that traditionally used to reside with the two political branches. And the judge ignored the fact that in our constitutional system, it is the two political branches who determine the president, but also Congress to a considerable extent, when aliens are admissible to the United States. And he actually did it by, forget the details of the opinion, but he took the view that our system of checks and balances is designed to preserve the fundamental right of liberty, and the judiciary plays a unique and irreplaceable role in that system. And that order, which actually was overturned by the D.C. Circuit and has been accepted by the Supreme Court for review, and with oral argument coming up, is part of a broader problem, which basically we have federal judges brought deep into the territory that was almost entirely reserved to the two political branches. You have cases after cases in the District Court for the District of Columbia where half a dozen judges have engaged in a kind of a weird notion of common law in the context of various habeas cases, not only disagreeing with the executive, but I would commend you an excellent study that Brookings just released, offered by Ben Wittes, that points out that on 7 or 8 key issues, the judges disagree with each other. And the chances of ever establishing any harmony, even within the context of judiciary, is pretty low. Now, bad decisions, take my word for it, and we can talk about it more in the question and answer period. But the principle that underlies all this judicial activism is well summed up in Justice Kennedy's oft-quoted statement in the Boumediene case that Naomi mentioned, that for the court to recognize areas of exclusive presidential and congressional power, ladies and gentlemen, free from judicial supervision, would amount to holding, that's a quote, the political branches will have the power to switch the Constitution on and off at will. It really suggests, implies an enormously expansive view of judicial power. It basically says that if executive, or for that matter, two political branches are operating in ways that does not give room for judicial engagement, that involves switching off a Constitution, because the Constitution always requires judicial engagement. Of course, that's rubbish. Their judiciary, Article III courts, are constrained as much by the Constitution as the other two branches. Judicial power has always been narrow. It's always recognized, whether you call it political question, whether you call it standing, that there are numerous issues that are not fit for judicial resolutions because they're either entrusted entirely to the two political branches, or by their very nature, because there are no ascertainable standards, there's no relief that the court can order that will be halfway effectual, just don't fit into the judicial vortex. The fact that this is not recognized is sad. Incidentally, the standing and the political question doctrine and various other limitations of justiciability have been eroded long before 9/11, been eroded in the last 60 years. But the fact that that it now applies with full vigor in the national security area is very depressing. I'm running out of time, so let me just make very briefly several other things. The court has, in the past, slipped its constitutional moorings, at least on 3 different occasions in American history, but it's usually taken decades if you look at the Warner and Burger Court jurisprudence. If you look at the trajectory of decisions here, where you begin with the Hamdi case, where despite some rhetoric about the fact that the president is not a king, it is basically a completely correct articulation of a traditional principle, and forget the precise issue, the fact that the president can classify an American as an enemy combatant. There's a perfectly standard recitation of existing jurisprudence. In the space of less than 5 years, when you get to Boumediene and the decisions by the lower courts since Boumediene, it changed. Never before in our constitutional history have you seen that profound of a transformation without the acknowledgement by, ladies and gentlemen, at any point in time that they're really changing the law. It's always tweaking it slightly and applying it slightly, and watching the way the court tries, for example, to claim that they really have not deviated from Eisentrager, which is a key decision, is not good. I will close by pointing out it's not just about Guantanamo. It's not just about habeas. It's certainly not about Guantanamo, because there's an effort now to expand habeas to Bagram and four corners of the world, with an excellent argument just held in the D.C. Circuit. Hopefully the Supreme Court would leave it alone. But it's beyond detention issues. We're now talking seriously about people writing articles, law professors, that argue that things like use of predator drones, insofar as they involve decisions by the executive, probably not only the executive, because those issues get briefed to Congress, about who gets put on the list to be targeted. Those decisions cannot be trusted entirely to the two political branches. Those decisions have to involve a judiciary. Now, it sounds crazy, maybe something one would laugh about, but if somebody told you 5 years ago that judiciary would be involved in the decisions involving the habeas application by an alien enemy combatant held overseas, that would have been crazy. That's not what the Constitution intended. That's not a good thing for this war. It's frankly not a good thing for judiciary. But I've seen no pushback, and I'll close by saying one of the things that depresses me about what has happened since the elections, my hope was that some of it was sort of aberrational and a bit partisan, and I was hoping that the courts would be more deferential to the successor administration, that the Congress would be more willing to step up into this void, and because they do have a role to play. Unfortunately, that has not happened, so the problem is certainly bipartisan. The problem is very serious and very, very enduring. Thank you.